continuous 700 years of daily namaz at page E, we have said. The 1907-8 and 1927-28 survey says it is a namaz place, a masjid.
Christian church taken into a mosque, but as of today, nobody offers any worship there, but they maintain the place as it is.
We will not comment. I have been to that place. I have myself seen it, but I will not. I don't agree what you say, but I will not comment on it.
In 1997, because up till then the directions were, this is a mosque, this will always be used in the mosque. The other community, the Hindu community, does not have the right to offer prayers here.
The judgment your lordship is hearing is reserved on 13th. All this, I just realized, all this repeated intervention, 2 months, is a red herring argument. It's an irrelevant argument of Mr. Tushar Mehta. The larger issue is, I'm only oralizing with the issue-wise. First and larger issue, which your lordship will decide on the hearing, I understand. Well, there is India is one of the country of layers of history. Layers will always be there. If you go behind layers, there is no end. It is Gandhiji's an eye for an eye, everybody will be blind. That is the rationale behind the 91 Act enactment. The SOR says that we make a one-time exception for Ayodhya. We will not. I accept that some of these may have, I'm not talking of this, some of these may have had a temple. There may be a temple, a Jain temple apparently supposed to be under the Qutub Minar. As a Jain, I was taken there and shown something. But that is no reason to go back on layers of history till time starts. That is why 91 Act in the SOR was enacted, number one. Now, there is the larger public interest of 91 Act being preserved, otherwise there will be chaos in this country. There is no end to it. This is not a general point. Your lordship has an actual order by a high court in Allahabad saying that somebody should at least start a survey of the Taj Mahal. And I'm not about particular. This can go on endlessly. So the quietus is the idea in public interest by an enactment which is either not set aside or the 91 Act is pending challenge and decision by your lordships in a validity petition. Second, just 2 minutes more. I'm sorry. Second, now, the impugned order, with greatest respect and humility, does a sleight of hand in interpreting it knows the 91 Act is a bar. The 91 Act section 3 is a complete bar. The impugned order invokes 4(3), which is a exception to 4(1) and 4(2), not to 3. And says that the ancient monuments system can operate. Number 3 is very important. There is a continuous 700 years of daily, I'm not asking for that, but continuous 700 years of daily namaz at page E, we have said. The 1907-8 and 1927-28 survey says it is a namaz place, a masjid. Post 1947, the Khasra Khatoni at page 286-287 say it. The MP Waqf Act notification at page U says it. The most important, the Dhar Area Darbar Gazette. Your lordship knows it was Rayat, it was the Darbar. They issue a gazette in 1935 at page 285, that says it. And therefore, namaz is allowed along with Basant Panchami. Actually, it's an excellent example of communal harmony, if I may say so. From 12th of May 97 order, they allowed namaz at fixed times along with Basant Panchami every year. It continued from 12th May 1977. Then the most important order which I am asking to be replicated today in the interim till lordship hears it. From 7th of April 03, namaz is allowed from 1 to 3 p.m. Basant Panchami is celebrated the whole day. And Hindus on Tuesdays can use it for sunrise to sunset. From when is this going on, the deepest humility? From 2003, uninterrupted. In between, when a writ is filed by the Muslim community, that writ is held to be non-maintainable, saying go to a suit. That writ is carried in writ appeal. It is pending, saying let the writ decide. While it is pending, the Hindu community, the current one, goes in a writ. The impugned order is passed, ignoring a coordinate bench which says you can't have a writ, go to a suit. Yeah. And this Mutawali, which is for whom I am appearing, who is the person who has gone there, is not allowed to be impleaded. The court holds you may have a right of audience. With deepest respect, this is a larger issue. Well, your lordship has one word in the preamble, which is the most forgotten word, according to me, possibly the most important: fraternity.
And security.
You have then secularism, and fraternity and secularism cross-fertilize each other. I am asking myself one question, Manus. If there is a 91 Act which says directly one-time exception Ayodhya, and there is a 7403 continuing uninterrupted interim order by your lordships, observed till today, then between now and then, something which has continued for 23 years, your lordship decides the matter, that should continue. Now turn to that order, Manus, for a minute.
My lord, only one
It
thing
is an
before my learned
example
friend,
of
my lord,
criminal
starts
hardship.
on the merits. There is something, my lord. The order impugned is 15th of May 2026. It's 2 months down the line. My lord, several things have happened. My lord, I appear for the administration for the state of Madhya Pradesh. Several things have happened, my lord. And my lord, I have prepared a short affidavit, my lord, whenever it's necessary, my lord, or required, my lord, I'll place it on record. My lord, right now, your lordship's, my lord, suggestion that it may be heard at the earliest. My lord, we can assist your lordships, my lord, on that.
In fact,
But
I
we
want
have,
to
my lord,
join in
for
the
administration, we have ensured, my lord, that both communities, my lord, keep calm. This
See the
any
order
kind
at
of, my lord,
306,
status
Mr.
quo
Mehta will
enter
agree.
without hearing.
Really, my lord, the
I am
ante
sure
which
Mr.
create the
Mehta will
problem.
agree if he sees
That
the order
is the
305, page 305. Just see the order.
They are really in
I
effect
don't
and in
understand,
substance asking
Malas-
for a stay. That's
Yeah,
what
one
they are
second,
asking for.
one second.
And they are saying status quo ante.
Ante.
PIL
That's really
petitioner
what
may
they are
not
asking.
agree,
That's our
but Mr. Mehta should agree. 306, page 306. PIL
No, it's
petitioner
not
may
a
not
question
agree.
of agreement, but once you come after 2 months and 6 status quo ante, the administrative problems come.
No, but the High Court then should have, in all fairness, stayed its own order.
No, my lord,
But let's kindly
But
see,
that
there's
has
a
not
fairness.
done. You should have
the-
done
I didn't come after,
Exactly.
I didn't
They had
come
the
after
opportunity.
1.5 months. There
came
was a
after
vacation
26
period.
years. You came after
Shouldn't
23
the High
years.
Court, Malad?
You came after 23 years.
Malad, I'll address after
First
Dr.
of all,
Singhvi
our-
finishes.
Malos, is one thing that I
Can,
think.
can you, no,
Can
306.
we also make one small request?
Yes.
These are very sensitive matters. What is happening inside court number 1 can unnecessarily create
Yes.
wrong impressions, wrong messages at different
Yes.
points.
Absolutely.
We should be extremely careful in using any expressions or anything.
Lordship.
We not first time this interim arrangement issue is coming before us first time. Earlier also we have dealt with the High Court and the helplessness of the state in maintaining on certain issues, on law and order issues. Those have also been taken notice in the interim judgment. Also we have seen it. That's why we just thought that whatever system is there, if we can list in after 10 days, 15 days before a bench.
Absolutely.
My problem is that first bench, I have already said that 7 judge bench matters we are starting and 3 judge bench matters are going on. If you both sides,
Any earliest date, my lord,
We bow down to that.
That's all right. That's very nice to say. Manoj. I can't say more than this. Of course, also your lordship, 9 judge, 25, 26 articles will also have a very clear impact on the whole thing. Just note the order of 306 for 1 minute. Then your lordship will see whether this is the most outstanding example of Samanvay and harmony. Just see this. It's worked itself out for 23 years. Of all people, why should Mr. Mehta's client, the government, oppose it? 7th of April 2003. In item 57, yes, in item 57, sure? Page 306, page 306.
This is 2003, this is set aside.
Yes.
So in fact, the problem would
After
have been
23
solved
years,
if
Mr.
they would
Mehta,
have
it is
immediately
set aside
moved the
after
matter.
23 years while the appeal is pending here.
No, they would
I
have moved
gone
the
chatted-
matter earlier,
allow
they
me,
filed
allow me,
it in
please.
May and moving it, my lord, in
Please allow me,
July
please allow me to complete my sentence. I, Gon Chatterjee, Director General ASI, in exercise of powers conferred on Rule 4 of the ancient so-and-so rules, in partial modification, all my 3 lords have it, please, do hereby direct that the central,
this order we have read in earlier round of meetings.
Exactly.
this has covered, it has worked itself out, it is a good via media. It's a good via media to preserve stability. And prior to this, it was only the Muslim Samaj, this namaz followed by Basant Panchami. This expands it and says every Tuesday from sunrise to sunset, Hindus shall have a right. So it's an expansion.
It's a matter of 10 days, my lord, your lordships can always do that, my lord.
Malad,
My lords, I just
also
want to
wish
say one
after
thing
my
for my
learning.
lord's consideration. There is a consent, there is a kind of a understanding. It is called Sahmati. It is dated 23rd of April 1995. Apropos to which both parties have agreed to use it as an religious place, both the Hindus as well as the
Despite
Muslims.
these-
They are
despite-
doing that continuously from 1995 under that Sehmati document until date. Now, my lord, so far as the maintainability of a writ itself is concerned, after the order of the learned single judge saying that the writ is not maintainable originally and saying that it is to be relegated to a civil suit, it was carried in an LPA brought before my lords before this court, and that order attained finality. So today, if there is an order which has clearly said, in this given factual facts, a writ is not maintainable, and my lords have put the approval on that particular order, it has attained finality, I would ask myself a question that how would a writ now, and particularly when a suit is pending, it has been filed, a writ, in a writ, this present order comes to be passed. My lords, I would lastly end it by saying one thing, and I appeal to my lords in that. I think Sophia Haya in Istanbul is a classic example. A Christian church taken into a mosque, but as of today, nobody offers any worship there, but they maintain the place as it is. My lords, many other countries,
Which place are?
Istanbul,
Hagia Sophia.
Hagia Sophia, my friend is talking.
classic example
We will
of
not
maintaining
comment. I have been to that
harmony.
place. I have myself seen it, but I will not, I don't agree what you say, but I will not comment on it. That's
My lords, I leave it.
one
That
of the-
would be
one
a
of the
view.
most
My lords
beautiful-
would have a different view. I would leave that. But I would respectfully submit that today, if we have an understanding document between the communities, they have acted upon it from 1995, and we are 30 years, 31 years from that. And my lords, there is a judgment that has attained finality on the maintainability of a writ petition, and there is a suit which is pending.
That is an issue, we are inclined to
So,
determine that issue.
For the
But
interim.
Maintainability will
Therefore,
be an
the
issue to be
interim. I come
examined
to
by
the
this year.
interim. I come to the interim. I would say, my lords, most respectfully, and I would request my lords to consider that if for these years and generations together, there has been a mosque which dates back to the 12th century, 1200. If the mosque dates back and has an antiquity of that date, and there are worship that is being offered for the last over 800 years. My lords, why should that be discontinued now? My lords will decide, but if the parties have also been doing it in harmony, that's the best thing that can be taken forward. I would say after 800 years, to stop worshipping by a community, my lords, it'll be a little bit too harsh. And frankly, if the parties have been jointly doing it under a settlement of 95, why should that not continue to hold the field till such time as my lords decide on the matter?
No,
Because we may have different views on different things. I don't have an issue there at all. But the fact does remain that what would be the arrangements that would hold the
when
field, my lord?
your lordship issues notice, your lordship
appeal-
just continue the interim order if there is an interim order or status continuing in the High Court order. This is changed only by the impugned order. This is changed only by the impugned order.
So should we please be over conscious rather of, let us not pass any order which might lead to creating tension and law and order crisis at this court.
It is.
We should all be very cooperative on that part. We are ready to hear the matter on day-to-day basis. I will request, even if it comes before our bench, there is no difficulty. Even if it goes to other bench, we'll list it, we will request the bench to take it on day-to-day basis, resolve the issue finally. These arrangements were there, the archaeological surveys order has also been creating problems. And Mr. Salman Khurshid will appreciate, because in some of the matters earlier came before our bench.
Yes, he had appeared.
Despite these arrangements made by Archaeological Survey of India or subsequent modification by that, there have been issues at the site, and because of that, some intervention was made at that time. So
Well, as if it is
it's a
continued,
matter where both sides, we will request, should have patience, and it's a matter of, it can be 2 weeks, 3 weeks. You should also be ready, they can also be ready.
Yes.
for-
My lords, I bow down, my lords, to what is falling from my lord, the Chief Justice. Given the nature of the matter, the kind of order passed by the High Court, I respectfully submit, let it be taken up for hearing, my lords. That's only appropriate in the facts and circumstances, my lords. I bow down, we will cooperate, my lords, we will argue straight away. Because that's the most imminent
The administration
approach.
has been very, very careful in choosing my words also. Because since they have chosen to come after 2 months, some events have taken place. And now with the intervention of the administration, situation is calm and peaceful. Lord, let that not be, my lord, muddled. And it's a matter of 10 days, my lord. They
No,
they could
can-
have
can I be
come
correct?
immediately on 15th of May, 16th of May, 17th of May.
But,
But now we are on almost, my lord, 2 months. So therefore, my lord, I believe, my lord, with profound respect, my your lordship, my lord, rightly considers, my lord, that it needs immediate examination.
And today they would really be arguing for status quo ante, my lord. That's really the problem.
That's the only
And the
thing that-
2003 arrangement, what they are repeatedly talking about, you cannot perpetuate a problem. And that has now been seen to be incorrect by the High Court.
My petition was filed on 20th of May. Serial.
So all the more reason they should have pushed it earlier. my lord.
They didn't move it.
3 out of 4 were filed in May.
my lord, may I,
3 out of 4 were filed in May, and if there has been
All the
no
correct,
serious
but-
disturbance,
correct, but
the
kept
government
in
can
defense,
maintain
did not
Malus
move.
peace now also under your lordship's order.
my lord, I take your lordship's point. May I just respond to it very briefly? So there can be two ways of my lords looking at it. If I may just complete the narration, two more facts that I want to state. After my lords pointing out the government gazette of 1935, which shows that at least since 1935, this continued to get used as a mosque. When your lordships are speaking of the spirit of accommodation, the spirit of accommodation, my lords, on behalf of this community, came in immediately thereafter in 1997. Because up till then, the directions were, this is a mosque, this will always be used in the mosque. The other community, the Hindu community, does not have the right to offer prayers here. That was, my lords, the manner in which it was proceeded with. Now, in 1997, my lords, the Muslim community agreed that very well, in 1997, there was an order by the collector. And the collector said that you may have Friday namaz in this particular mosque. And, my lords, let them have access to the monument. And, my lords, on the occasion of Basant Panchami, let them do, my lords, whatever prayers. This was, my lords, sorry,
Tuesdays. Tuesdays.
Subsequent.
subsequent.
Tuesdays were added.
Firstly, in 1997. So when your lordship said there must be a spirit of
Only on Vasant Panchami day.
Basant Panchami, and they can enter and probably use, but they will not cause any disturbance to prayers, even on some other days, or even on one particular day. That is thereafter, my lords, solidified into an order of the ASI of 2003, which your lordship just saw, where under, my lords, the accommodation was that you can have pujas on Tuesday, and the Muslims will have namaz on Friday. This has stood the test of time
23.
till such time that they filed a writ petition. First, my lords, I filed a writ petition. One of the parties, the Muslim parties, filed a writ petition, even challenging, my lords, the grant of rights, my lords, to the other community for, my lords, prayer on Tuesday. That was separate. That was dismissed by the single judge saying disputed questions of fact go in a suit. So far as, my lords, they are concerned, their writ petition against the ASI order is filed only on, please don't interrupt. Now, insofar as that is concerned, my lords, what was said was that thereafter, my lords, for the first time, their writ petition comes in the year 2022. So the ASI order, my lords, has held the field from 2003 to 2022. Now your lordships were pleased to observe that there is an adjudication by the High Court. Now what happens? The impugned order, my lords, is passed by the High Court on 15/5/2026.
Now, we are pointing out something else.
Yes,
That before the High Court's adjudication also,
yes,
there were occasions when some very stressful moments came.
yes, yes.
And those were resolved by us with the help of Mr. Pusid and
Yeah.
the other side.
Yes, so I am obliged, my lords. If that resolution that your lordships effected while the matter was pending is to continue in the interregnum, that can be one way out.
That is one of.
That resolution, the orders that you, because, my lords, now today the situation is we are completely elbowed out.
Just see what, sorry.
That's why we are saying that.
Yes.
some
One fact we missed
adjoining-
out, Balas.
Some adjoining area.
Yes,
Can be earmarked for the purpose of offering namaz,
yes.
and that arrangement without prejudice to the rights of.
Yes,
the
only as an ad hoc arrangement,
No,
not that
but
they
Balas,
will give up their right.
My lords, just one thing. The adjoining area, my lords, this today has some religious significance. For the purposes of Friday prayers, this particular, my lords, complex it has a particular pulpit on which, my lords, there is an observance of prayer which has been going on, which is also of religious significance for us. So on one Friday, if in a week, we are permitted to offer those prayers, which we have been doing since 1935. My lords, I am just pointing out one more thing.
My lords,
Your lordships,
very-
your lordships
so much
were
can be
pleased to-
argued. It is of
Your
significance
lordships
on the
were
other
pleased
side
to-
also, my lords.
Your lordships will be pleased to, my lords, my learned friend never does this in other matters, my lords. Why is he doing it in? this?
I'm doing it in this matter because
Yes,
my
very
friend
good.
is going on.
Let me
We are
finish.
thinking of
Please
an
don't do
arrangement.
it. Please don't do it. Let me finish. Now, therefore, my lords, after so many years, if the learned single judge even wanted to allow the petition, in my respectful submission, and this is, my lords, my ground for interim relief, should his lordship, my lords, I ask myself this question. Not, my lords, have stayed the order for a period of 2 weeks or 1
Come
week.
immediately.
One point.
Can
The high,
put in
the
effect
government,
for 2 months.
after the order is passed on that particular day, the learned single judge doesn't stay his own order, even for a period of 1 week or 3 days, giving us, my lord, some kind of a platform. The very next day, there is an order passed by the state, which says that ASI, saying that this is how we are going to implement it.
That-
Muslims are out of this particular property. They can't really enter. And, my lords, therefore, now we are sought to be presented with a fait accompli. My learned friend orally said, my lords, I'll just finish in
Yes.
one way. My learned friend orally said, they are asking for a restoration of the status quo ante. But what are they getting? You are altering the status quo, which has gone on from 1500 up to the date of the order. Now, therefore, my lords, where does the balance of convenience lie? And today, my lords, in all fairness, is it, my lords, proper to, on a point of balance and of convenience and irreparable injury, to oust out one community, which has been performing, my lords, over there for so many years?
On that 1 minute only, my
Yes.
mistake, I did not say it, is very important for your lordship's interview. It will take 1 minute. The judgment your lordship is hearing is reserved on 13th. All this, well, I just realized, all this repeated intervention, 2 months, is a red herring argument. It's an irrelevant argument of Mr. Tushar Mehta. 13th judgment is reserved. 15th judgment is delivered. Now turn to page 715 in any file. This is very important. One document. That is 16th, item 22 or other item, page 715. Judgment reserved on 15th. On 16th, the ASI issues a letter under the Ministry of Culture saying, the Hindu community shall have an unrestricted access to Bhojshala complex and the others will not in 1 day. Even if I had somersaulted into the Supreme Court the next day, I could not have got a stay of this. So this is just a red herring argument. Has your lordship seen this alacrity? Both your lordship arranged for both to
Let us not,
on the next day.
let us not doubt too much on this kind of matters.
Check up.
A delay, a day's delay can have very serious repercussions.
Absolutely.
A day's delay, sometimes please see the psyche, we have to see the common man, how they behave, how they act, how they react.
So the prior state
We mentioned at 10:30 many a time, that order is passed yesterday, not stayed.
either it should
Please
have
take it
stayed
up
like
today.
Mr. Ahmadi is saying, or they should have given me 2 days to come here. Just see the order. Manas. I have not yet seen an order like this.
We understand that.
It says
but
on a
today,
Saturday.
Please appreciate
1
that
day later.
once a court makes a judicial declaration on a particular day,
Yeah.
and if you fail to react and act sometimes keeping in view the peculiarity of the situation, it might have very serious consequences at this court.
Next day on a Saturday.
Lord, I didn't want to say
No,
this.
it's an order running into
Mr.
242
Ahmadi filed his
pages.
petition on 10th July.
Access to
It was
one
not
community,
even filed on
changing
date.
the status quo
And
for
now he's
joint.
making an
Your
argument
lordship
about.
had jointness. From 7403, the latest status quo for 23 years was jointness. The impugned order changed it on 15th. On 16th, how can they write a letter? Just see the document of 715. I've never seen a document like this, Bruce. On a Saturday, the next day, they say one community is out altogether. And the other community by name shall have unrestricted access.
Will this argument really be an aid of staying of the judgment?
No, the
Because
of the
because
joint,
your
jointness.
argument is
Jointness.
that if you see Roman II,
Yes.
Roman 2, Roman 3, and Roman 5 have in fact been given effect to.
Correct.
You say that the judgment has been given effect to in post haste.
No,
When we are
I'm sorry to interrupt.
looking at the
What I'm
admission of
saying
this
is Mr. Mehta and the
application,
other side.
Apropos, my lord, the Chief Justice's
What am I saying?
observation,
three and
Mr.
Roman
Ahmadi's
five have taken
SLP,
Right, I am saying, my learned friend's argument is, now your lordship is restoring status quo ante. We wasted too
Why
much
they are
time.
saying
We
status
wasted-
quo ante is because of that.
Come.
That we
Absolutely.
are looking at a
I-
judgment which has been partially given effect to,
But the next-
albeit
I could not
in
go faster.
post haste.
Absolutely.
Albeit in
Lord, another thing, Mr. Ahmadi's SLP is filed on 10th, we are on 13th.
Mentioned
My lords, also, I would request in terms of a prima
Joint
facie
should be there.
test.
Cannot, my lord, wait for 10
Please
days.
have in mind that this is a mosque dating back to
That
1300
is-
where
That is
regularly
right.
prayers are being offered. Now if you test on
That is
that
why,
land,
madam, that is the reason why
Reason.
we want to balance the equities, not only on the prima facie case that has been so vociferously argued before us, but also the state of affairs which Mr. Solicitor and others have indicated that, see, here certain steps have been already taken. In this situation, we see Roman 7, where the rights are sought to be preserved in the manner the judge considered, which is subject to challenge before us.
May
We
I,
can set aside this order
Yes.
and restore back what
May I
was
res-
earlier there.
No,
May I
Mr.
respond?
Ahmadi has no
Action,
May I-
what
Urgency,
is
May I
our
just
proposal,
answer?
subject
There is
to
no
hearing
permanent,
further.
there is no permanent.
Absolutely.
Till a fortnight, whenever prayers are offered, without the equities being crystallized or any prejudice being caused to contentions of modification in future, that the prayers be offered in a place adjacent to this mosque or to the declared temple. The manner in which it was done during the hearing of the writ petition.
No
Because
idol is
during the
installed.
hearing of the writ petition.
No idol is installed.
there
A
were-
cardboard image is kept every morning and taken back every evening.
Correct, now
So,
the
there
idol
is
has
no
already
idol.
been installed.
no,
Idol has been installed.
there is no, I'm
Other idols, I don't wish to go into
Lord,
it.
sir,
When
now
Mr.
they
Ahmadi
cannot be, my
files
lord.
an SLP on 10th
my lord, may
July,
I?
why can't he wait, my lord, for a 10 days?
Background,
We are in 13th.
5 minutes.
My lords, each one of the, just
My lord,
for a minute,
this is-
each one of the arguments they are giving touching on merits, this has to be by both sides. It cannot be, they go on arguing on prima facie case where the court is thinking of an arrangement, interim arrangement.
My lords will just allow.
Cardboard image, no idol.
Sensational.
I
have
respectfully
today's
submit, my
position.
lords.
My lords, may
I
I?
have today's position on the photo.
We have heard enough, madam, let's not,
My lords,
we
just,
would have preferred to decide the main case itself, I think.
my lords, just 1 minute of your time, if you would allow me, please. My lords, it's a historically documented fact that Dhar suffered an earthquake in 12th century, which is around 1200, and everything there was destroyed. So there was no existing temple. It's a documented historical fact that the mosque was built in the 13th century.
दोस्तों, धार की ऐतिहासिक भोजशाला को लेकर माननीय सुप्रीम कोर्ट में आज बहुत ही तीखी और महत्वपूर्ण कानूनी बहस हुई। देश की सबसे बड़ी अदालत ने साफ कर दिया कि इस बेहद संवेदनशील मामले का हल कानूनी दायरे में और आपसी संयम से ही निकाला जाएगा। दोस्तों, माननीय अदालत अब ठीक 3 हफ्ते बाद इस केस पर रोजाना डे टू डे सुनवाई शुरू करने जा रही है, जिस पर पूरे देश की नजरें टिकी रहेंगी। आपकी इस महत्वपूर्ण मामले पर कीमती राय क्या है, कमेंट्स बॉक्स में जरूर साझा करिए। जय हिंद दोस्तों।